Hello, Patrick. Which assessment are you referring to?
The last assessment.
The legal memorandum, you mean? Did you mean the legal memorandum?
The take-home paper.
Are you talking of the final written assessment or the one that the deadline of which was about a week ago? Oh, the final one?
The final.
It might be too soon. Too early for that.
Okay.
Yeah. I'll give the pointers about 2 weeks before the, maybe around the week 10. So it's too early right now to give the pointers. So we could probably begin at 6:05. We'll give it 3 more minutes and then we begin. So we could probably begin. Now, before we start talking about the discussion questions for week 6, would any of you have any questions? Anything you'd like to clarify? So none at the moment. Okay. So we could proceed. I only posted about 2 discussion questions for this week, and we'll try to change the facts as we go along for the purpose of trying to improve our understanding of the concepts that are part of topic 6. So in terms of the objectives, after studying this topic, you should then be able to discuss and explain the 3 key rules that a decision maker must observe in making a decision or in exercising a statutory power. Namely, a decision maker must exercise a statutory power according to the purpose for which it was conferred. In exercising a statutory power, a decision maker must not take into account irrelevant considerations, and in exercising a statutory power, a decision maker must take relevant matters into account. Welcome as well, Raymond. Thanks for joining us.
Hello.
Okay. Matt, rather. Matt.
Yeah.
Okay. So let's begin by dealing with the first discussion question. Can I ask one of you, perhaps Patrick again, to read the discussion question?
Yes.
Thank you, Patrick.
The Commonwealth Development Authority Act authorised the Commonwealth Development Authority to compulsory purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's Executive Committee meeting on 16th of May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purpose and acquisition of his property along Benwick Road, as authorised by the Commonwealth Development Authority Act. George does not wish to sell his property and has come to you as a solicitor for advice. He brought with him a copy of the 16th of May 2013 Executive Committee meeting of the CDA, advised Greg whether there are strong legal grounds to oppose CDA's offer to purchase.
Okay. So in a minute, can I ask you to state your answer in the chat box, whether there are strong legal grounds for Greg to oppose CDA's offer to purchase? Okay, we've got an answer from Andrew. How about from Raymond, from Matt, Patrick, and Jacqueline?
Yeah, I'm having trouble with my screen to how to use the chat box.
Oh, okay. Patrick, Jacqueline? Mm-hmm. Okay. And how about Jacqueline? Okay, so you don't see any legal grounds. Let's see. Under the Act, the Commonwealth Development Authority is authorized to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads. So that seems to be the purpose of the Act, and that's the purpose of the power given to the CDA. And yet, if you will notice, the Chief Executive Officer of the CDA has expressed an intention to purchase the lot. And in fact, he did with the support of the CDA Executive Committee. But the purpose of purchasing the lot was actually because he was thinking that the value of the property would appreciate. So, what do you think about that? Okay, so from Matt, so what is your answer, Matt? Do you think there's a legal ground to oppose CDA's offer to purchase?
it's being used for a different purpose. He wants to make a profit out of it rather than for the other reason.
Okay. So what would your answer be? Would there be a ground or
Well,
not?
no. I think there is a ground for objecting to it, because if they're just getting it to make a profit on it, or he's going to lose the.
Okay. So, yeah, thank you, Matt. So the correct answer here is the one expressed by Matt. When a power is given to a decision maker, and the power has clearly expressed the purpose for which the power is to be exercised, or has indicated what considerations or matters should be considered in making a decision, and yet some other matter or consideration is used in arriving at a decision, then in that case, the decision of the decision maker will be ultra vires. So in other words, the rule is, if the power has expressly stated what the purpose is of the act, then the decision maker must only act according to the purpose of the act, or the purpose for which the power was given. He cannot go beyond that which the act allowed, or he cannot consider any other matter which is not within the act. So in this case, the desire of the chief executive officer to purchase the property on the basis of some speculative purpose, because the property was going to speculate, goes beyond that which the act authorized the CDA to do. So yes, Patrick.
So what you're saying is, by him trying to purchase it, he's exercising outside his authority.
Yes, because the authority of the CDA executive the authority of the CDA itself is circumscribed by the purpose of the act, and the purpose of the act is quite clear. It's to purchase property for to meet the infrastructure needs for new roads and highways of the Commonwealth. And it's also circumscribed by whatever the act may determine are relevant considerations or relevant matters. Given the facts that we have here, there is no indication that one of the purposes of the acquisition or the purchase should be for the CDA to be in a profitable position. That is not one of the purposes of the act. And neither does the act state that one of the key considerations or matters that it should consider would be the possible appreciation of the property. So for the CDA Executive Committee, therefore, to come up with a decision to purchase the property on the basis of something that is not authorized by the act would be ultra vires. And for that reason, Greg would therefore have a legal ground to oppose the CDA's offer to purchase. Okay, was that clear enough? Okay, good. Now, let's see. Looking at this further, what if the CDA will raise the argument that it actually intended to purchase the property or to acquire the property in order to meet the infrastructure needs for new roads and highways of the Commonwealth, and that it was just an afterthought, or it was just a way of strengthening their decision for them to consider the fact that that specific property was bound to appreciate in value at some point. So in other words, the primary motive is actually the purchase or the acquisition of the property to meet new roads. And it only strengthened the decision of CDA to purchase the property once they realized that that specific property was going to increase in value at some point. So there are two purposes, therefore, when the CDA arrived at its decision to acquire or purchase the property. One was consistent with what the Act provided, and then there is another motive which has appeared, and that is because the CDA is aware that the property is going to increase in value at some point. So if that were the case, what do you think will your position be? Will there be a strong legal ground to oppose CDA's offer to purchase?
It doesn't become so clear then, because if they can successfully argue that they're land banking to put that aside while they do planning and while they do approvals and maybe look at future planning, there could be an argument that they're actually doing it for the correct purpose. The argument on behalf of the aggrieved person here or the plaintiff here would be that they'd want, you know, proper compensation for their property if it's a matter if they're not going to build the thing straight away. So governments and developers do land banking where they buy land now for future projects. Future projects is the proper reason, is the reason why they want to comply with the Act, but there'd have to be a very good argument for them to be able to do that.
Okay.
Perhaps that's an option.
Yeah, but how about the fact that there was an ulterior motive? And the ulterior motive, or the motive that was actually part of the factors that the CDA considered in making the decision to award the land, was because of its knowledge that the land was likely to appreciate in value at some point. Would that taint the decision of CDA? Is somebody raising his hand? But the name isn't there, so I'm not sure who's raising the hand.
Yes. Yeah, it's me, Patrick.
Oh, Patrick. Yes, Patrick.
So just to your point, would that be the fact that he is proposing, but doesn't mean whether it's necessary for that development to go ahead?
Can you repeat that for me?
Would it be the fact that the executive is proposing to purchase the land, but he's not really justifying whether it's necessary for him to purchase or acquisition the land for that construction purpose?
The issue really here is that on the one hand, the primary purpose of the purchase is actually according to what is stated in the Act. And the primary purpose, therefore, was actually to meet the infrastructure needs for new roads and highways of the Commonwealth. However, there seems to be another purpose behind the purchase as well. It just happens that apart from the fact that the purchase of the land is likely to be able to meet the infrastructure needs for new roads and highways, there is another motive, and that is the motive that they're trying to make the purchase because the city is aware that the land will appreciate in value at some point. So the question is, what is the significance or the effect or impact of any of the fact that there is another consideration that seems to be the motive behind the purchase of the property, going beyond that which is stated in the Enabling Act?
With that consideration that the land's going to be appreciated, is that relevant? Because they've got to build the roads and highways eventually, and not with whether or not there's going to be a big commercial complex there. If they're planning to build the roads, it would seem a sensible decision by the government to buy the land and do their planning earlier. I don't think that's relevant.
Okay, the thing is, in terms of the way that decisions are supposed to be made by decision makers, we are guided by 3 rules. One of obviously is the first being that the decision maker must exercise his powers according to what the law provides. That's one. But the second aspect is that the decision maker is required to consider whatever factors or considerations are required to be considered. And the third rule is that the decision maker is not permitted to consider irrelevant factors or irrelevant matters. So it would appear here that there is an irrelevant matter. In other words, the desire to purchase the property is motivated or actuated by an irrelevant factor, and the irrelevant factor seems to be that the land will appreciate in value. So therefore, that goes against one of the guiding rules that ought to be considered in determining whether or not the decision of the decision maker is valid or not, or legal or not. So that's the question there. I mean, are we saying that what is the effect of that ulterior motive or that secondary motive, for example, that the purchase was actually motivated by their desire to make a profit out of that purchase or acquisition. Does that affect the validity or legality of the decision of the CDA? And Matt, you were saying that it shouldn't, because what? Because it's irrelevant?
Whether or not that commercial centre is built or not, and the prices rise, the property value rises, they've got to build the roads anyway. So I believe it's irrelevant.
Okay. So the rule here is that we need to examine the decisions of the decision maker. And if we find out that one of the decisions of the decision maker, that when the decision maker arrived at a decision, he was actually actuated by, or was actually motivated by a factor that is irrelevant, that can potentially vitiate or impair the decision of the decision maker, which means that it's possible for the decision to be tainted and for it to become invalid because the decision maker has taken into account matters or considerations which are meant to be irrelevant to the decision. So here, even if you might say that the purchase or the acquisition of the property was actually according to the main purpose of the law, which is to meet the infrastructure needs for new roads. But because there is an irrelevant consideration, and that irrelevant consideration in this case seems to be that desire to profit out of the fact that the land may appreciate in value at some point, that can taint and impair the validity of the decision maker. Now the question is, because of the possibility that the validity of the decision may actually be tainted or impaired because of the consideration of an irrelevant motive or an irrelevant factor, the basic question we ask is, how significant or how substantial was that irrelevant consideration in arriving at the decision of the decision maker? Okay, so the mere fact alone that there is an irrelevant consideration that has entered into the picture when a decision maker made a decision does not by itself invalidate the entire decision, does not by itself taint the entire decision so that the decision becomes invalid. It potentially has the effect of invalidating the decision, but only if that irrelevant consideration is a substantial reason behind the decision, or that it is actually one of the key actuating motives for the decision. So we look at the strength or the significance of the irrelevant consideration. If it was just a question of, it came into our discussion that, in fact, the property will appreciate in value, but our primary motive for acquiring this property in the first place is because we really need them for new roads, then in that case, the decision will be valid. But if it appears that one of the key considerations in the purchase or the acquisition of the property was because the CDA was aware that the land was going to appreciate in value at some point, then that taints the entire decision-making process and therefore would invalidate the decision. So the question is, was the irrelevant consideration therefore a substantial consideration that was taken into account, or was it one of the key actuating motives behind the decision? But the mere fact alone that some irrelevant consideration may actually be considered does not by itself vitiate or impair the decision making. After all, when a decision maker arrives at a decision, it is possible and likely for the decision maker to kind of consider all possible reasons for arriving at a decision. And just because the decision maker considered all possible alternatives or all possible consideration or all possible factors, that process will not impair the decision making. It is only when an irrelevant consideration enters into the picture and that becomes a substantial reason why the decision was arrived at in the first place. So from Andrew, that sounds fair, but hard to argue that you think it was for reasons other than future need. Yeah, so at the end of the day, it might be a question of evidence. It might be a question of evidence. In other words, remember, it's possible for somebody who's affected by a decision of the CDA, for example, to ask for copies of the minutes of the meeting. And if in the minutes of the meeting, it appears that one of the key reasons why the purchase of the property was made was because of the desire to speculate on the possible rise in the value of the property, then in that case, that will clearly invalidate the decision. So from Patrick, so what would be irrelevant but not substantial?
What I mean by that is that you said what was irrelevant but substantial was the increase in value. But then, so for a decision for it to be irrelevant but not substantial, what would be an example?
Okay.
Or does that come down to your arguing the case?
I just found the statement here of Andrew quite funny and revealing. He was saying, I'll go back to you, Patrick. He was saying that he has worked for the state government for 50 years, and governments are not silly enough to actually minute meetings correctly. Well, that's a valid point. Yep. So going back to your point, Patrick, so it's one thing for decision makers to actually come up with irrelevant considerations when they arrive at a decision. But it's another thing to determine whether or not that irrelevant consideration was actually a substantive consideration that was part of the reasons why the decision was entered into the first place. So an irrelevant consideration could be that there was going to be, hold on, somebody's knocking on the door. Okay, can you just give me a minute? Somebody's knocking on my door. Just give me a minute. I'm just going to check on who's knocking on the Okay, I'm back. So sorry about that interruption. So going back to your question, Patrick. So yeah, in all likelihood, when a decision maker arrives at a decision, the decision maker would often, if they really considered and examined the alternatives, they're likely to look at different factors, different matters. Some of those factors or matters may be relevant to the decision making. Some of them may actually be irrelevant in the sense that it is not one of those that is allowed or authorized by the statute or by the enabling act. So the fact alone, for example, that they may be weighing certain factors and some of those factors are irrelevant does not by itself vitiate the decision of the decision maker. Only the decision will only be vitiated or impaired and therefore become invalid if the irrelevant consideration was a substantial reason for the decision. Okay, so was that clear enough?
Yes, thank you. Thank you.
The other thing is, what if there is an irrelevant consideration in the sense that, as I said, like, you know, all of us, when we make decisions, we kind of factor different things. Some are important, some are not. And let's assume that when the decision maker in CDA, for example, looked at the key consideration being the, you know, according to the purpose of the act, which is to meet the infrastructure need for new roads. And one of the relevant considerations was that there was a desire to speculate on the land. It is a substantial motive, actually. So let's assume that the motive is substantial, meaning that irrelevant consideration that they wanted to purchase the land because the land was likely to appreciate in value at some point. Let's assume that that is a substantial reason as well, in addition to the decision to buy it according to what the law required. But the claim of the CDA is that the motive is good. The motive should be applauded. I mean, you know, what's wrong with buying a property because it is meant to appreciate in value at some point? So therefore, he is saying good faith, and he is arguing as well that it's a course of action that any sensible person would consider. The fact that the property will appreciate in value. So what if that kind of argument is being made? Good. So it's based on good faith, and secondly, you know, there are strong reasons why they should purchase the property because they'll end up with profits. Did you get my question? I think you did. Matt came up with a good answer. So that's a good point, Matt. So even if, you know, you may come up with all good reasons, you might have a good faith, you know, your motives may be based on good faith. It doesn't matter. The key thing is, if the act is clear in its purpose, then that should only be the motivating reason for the actions of the decision maker. Any irrelevant consideration, if they become a substantial reason for the decision, will taint the decision-making process, even if there was good faith in the decision, even if it could be argued that the irrelevant considerations actually make sense. They still remain irrelevant. Okay, are we clear about that? So so as Matt said, yep. Okay, so the primary purpose remains to meet the infrastructure needs for new roads. Okay. So we'll go to discussion question number 2.
I can read it, Meadow.
Yes, go ahead.
Under the National Business Risk Assessment Agency Act 2012, the National Business Risk Assessment Agency was created to examine, review, and assess the risks to Australians. Hey, I'm just going to...
Sorry.
Can you just widen up the screen a bit or something?
Are you able,
thank you.
You're having a hard time looking at it. I don't exactly know how the screen appears from your end.
Yeah, it's all good now. So,
Okay.
where was I? To Australia and provide policy recommendations in the area of business risks to the federal government. The Act also employed by the NBRAAA to review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRAA Executive Board, concerned about human rights violations and security threats in Afghanistan, Iraq, and Syria, passed the Restricted Commercial and Business Activities Regulations 2013, which imposed huge fines on any Australian business that conducted or engaged in any business or commercial activity in any of those countries without its prior written authority. The Hotbed Startup Proprietary Limited sought approval from the NBRAA to sell its products in Syria. When the NBRAA refused to give its approval, the company challenged the agency's legal authority to pass the Restricted Commercial and Business Activities Regulation 2013. In its letter to the company, the NBRAA pointed out that under the National Business Risk Assessment Agency Act 2012, it had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup Proprietary Limited has approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRAA.
Thank you, Patrick. Okay, in a minute, can I ask you to post your answers in the chat box? Okay, so we have an answer from Andrew. Oh, hello, Paul. Thanks for joining us. I hope you're being late today. It was not because you assumed that the class begins at 6:30, because in that case, it could have been my fault. But we actually start our tutorials at 6.
No, that's all right. My son's been sick, so we were just sitting down to dinner and I was scoffing that to get here.
Okay, yeah, thanks. So we'll give Paul as well a chance to go through the discussion question. And when you're all ready, just put your answers in the chat box and then we can start with the discussion. Okay, can we get a response from others? So we've got from Paul. Okay, Paul, the question here is whether there is a legal ground for hotbed to challenge the decision of the NBRAA. We're not yet asking about the proper forum, whether it should be judicial or it should be administrative. The basic question we have for now is whether or not there is a legal ground to challenge the decision. So from Jacqueline, I would think so. Which one do you think so? Do you agree with Matt? So are you saying that there is no basis for legal challenge? Is that what you're saying, Jacqueline? Just so I understand what you're saying. Okay, yeah, okay, good. So just as a pointer, you just have to make sure, especially when we have the final written assessment, that your answers are clear in the sense that, you tell me whether or not the act is valid or not, or there are legal grounds or not, because if all you do is make a statement and it's not clear what your conclusion seems to be, then that can be very problematic. So you need to be able to clearly articulate your conclusion, whether you think there's a legal ground or not. If you're not sure, or you think that your answer may depend on certain assumptions about facts that you make, then that's fine. But you have to be quite clear in what you think the answer is. Okay. So, so from Paul, I don't think there's a basis for legal challenge. From Jacqueline. So for Jacqueline, I think her conclusion is that there is no reason, there's no basis for legal challenge. From Matt, I think Matt is arguing that there is a basis for legal challenge, for a legal challenge. And what's your reason, Matt?
Well, you can review any of those decisions, but the question itself doesn't give you a reason why they've reviewed it, apart from the fact they're saying they've got broad and unqualified powers to validly pass and contested regulations. If the regulation says that they can't go to Syria and they can't do business in Syria, if you challenge that, doing a judicial review against that legislation there wouldn't help you at all. But if you did a merits review, perhaps that may give you a opportunity to at least get them to argue the case, and maybe a discretionary decision that they can, because if there's no reason, if they don't provide you with a reason, if there's a discretion, if it's put before a tribunal, a discretion may be able to assist you.
Okay.
Does that make sense?
Let me just clarify one of the points you said. So let's assume that the decision of the NBRAA wasn't disclosed. So what is the effect if no decision was actually made? From what we know about the Administrative Appeals Tribunal Act, what is the significance of, I'm not sure if we discussed this, but what is the significance of, or what is one of the more crucial aspects of the AATA when it comes to decisions of decision makers who have not stated the reason for the decision? Was that clear? So let's assume that a decision has been made, but no reason for the decision was actually given. Would you remember what the AATA, the Administrative Appeals Tribunal Act of 1975 says in that regard?
Maybe
no, it escapes me.
Sorry.
It escapes me at the moment. Does someone else know?
No, I don't know off the top of my head, and I haven't Googled it to find out. I'm sure somebody will. But
yes. So
I think it.
Yeah, go on.
Yeah, go on, DJ. No, you go.
Yep. So under the Administrative Appeals Tribunal Act, if an aggrieved or an applicant has a legal basis to file an application for administrative review with the AAT, then that applicant or aggrieved may actually compel the decision maker to provide the reasons for the decision. So let me repeat that. If the applicant, under the Administrative Appeals Tribunal Act of 1975, if the decision of a decision maker is one of those which according to the act on which the administrative decision was made, is subject to an appeal, is subject to a review with the AAT, then in that case, the applicant or the aggrieved has a power or a right to compel the original decision maker to provide a reason or the reasons for the decision. So was that clear? So that's a key point there. Under the AAT Act, the moment that an administrative decision, if that can be the subject of an administrative review by the AAT, because according to the act under which the administrative decision was made, that a review could be had with the AAT, then in that case, the applicant or the aggrieved will have a right to compel the original decision maker to provide the reason or the reasons for the decision. So I'm just trying to clarify that because of the point that Matt was pointing out. Now, if you look at the facts here, there seems to be, as pointed out by most of you, including Patrick, there seems to be a very broad power given to the agency by the Act. It says here, for example, that it is empowered to review its statutory mandate. Imagine that, it can review its statutory mandate. It has the power to broaden the scope of its purpose and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this act. Okay? What is the significance of that provision? Because it is a very broad provision and it's a very empowering provision in the sense that it gives the agency a lot of power. It can review its statutory mandate, can even broaden the scope of its purpose. So what is the effect of such a broad provision? Is it a quasi-judicial power? No. I mean, it's quite clear that, in a sense, this agency is not exercising a quasi-judicial power yet, although it is, because it seems to be reviewing it has the ability to impose fines. So it is, in a sense, exercising quasi-judicial powers. But the question for me was, what is the significance or effect of having such a broad mandate coming from an act?
Perhaps it's to allow greater decision-making to minimise the risk to these companies or people who want to run a business outside of Australia and they need to have quick decision-making. I don't know, I might be wrong there. Like executive action.
Okay, so the question I have here is, given the very broad provision, imagine, saying review its statutory mandate and broaden the scope of its purpose. What is the significance, the legal effect of such a provision? Does it mean that on the basis of that provision, the agency therefore has unlimited powers to decide what its purpose might be? Does it have unlimited authority to determine what the risks ought to be to Australia. And therefore, and in that case, it can no longer be controlled by any administrative agency or even the judicial branch of the government. So I'm looking at the answer of Paul. So let's think that through. So there seems to be a carte blanche. It's almost a blanket authority. What is the effect of a blanket authority? Kind of. It's almost like a blanket authority. Does it mean that if there seems to be a blanket authority, it actually is? So that therefore the discretion or the exercise of the power is unlimited and unfettered and uncontrolled or uncircumscribed? Is that the effect? Okay, less scrutiny. Would it mean it's uncontrolled? How about the others? What do you think?
I think in this circumstance, yeah, it means that they can change and add countries and things like that. They don't need to justify it. They can just add it and expect you to abide by it. So therefore, it is unfettered or uncontrolled. My thoughts. Okay.
Can I hear from the others? So the point being that if there seems to be blanket authority, does it actually mean that the authority is unlimited? Is that what it means? Oh, from Andrew. This is even a more, a bigger statement here. I think it is uncontrolled, and I think it restricts oversight by the judiciary. Aha. Very interesting. Can I get the views of the others? Not sure about unlimited. Yeah. Okay. The point here of Paul is actually correct. There is no such thing as beyond the review of the judiciary. There is no such thing. The moment a decision is made by an officer of the Commonwealth under Section 75 of the Australian Constitution, it is within the power of the High Court, for example, to issue writs of mandamus, prohibition, or injunction. It is always subject to review. And the High Court has already ruled that there is no law that can oust the High Court of its original jurisdiction as provided in the Constitution. So the Parliament cannot pass a law saying that this is beyond the power of review by the courts. It can limit, perhaps, the scope of judicial review, but it is not within the power of the Commonwealth Parliament to oust or deprive the judiciary of its power to review decisions or actions of officers of the Commonwealth. So let's just clarify that. Now, so going back to that question, assuming that, as we see in this provision, that the power seems to be broad in scope and almost unlimited, the mere fact that the provision seems to provide unlimited power or unlimited mandate does not mean that the agency actually has full discretion or untrammeled authority. So even if, let me repeat that, even if the provision appears to give the agency unlimited discretion or unlimited power, it does not necessarily follow that the agency will actually end up with a limited power. The agency will still have to exercise its power according to the purpose or aim of the statute. So that will still be a constraint. Or the exercise of the so-called unlimited powers of the agency will still be circumscribed and limited by the subject matter of the that is within the legislation. So are we clear? So what it only means is that if there seems to be very broad statement on the authority or the power of an agency, what it only means is that within the scope, boundaries, or aims and purposes of the statute, the agency is free to make any decision within the scope or boundaries or purpose of the statute. But beyond that would be ultra vires. It will be an ultra vires exercise of power. Now, in this case, if you will look at the purpose of the statute, it is actually for the agency to examine, review, and assess business risks. So that is the purpose. Examine business risks. And it says as well, provide policy recommendations in the area of business risks to the federal government. But if you will notice, the board is saying that it is arriving at a decision to impose a fine on the basis of its concern for human rights violations and security threats. That seems to be going beyond the scope of the statute. So it will be not so much acting outside its advisory or review role. The agency is acting outside of the powers that are conferred on it by the act or by the statute. So when a decision maker makes a decision, one of the primary rules is that the decision maker must make the decision within the confines of the power that has been granted to it. It cannot go beyond. And as I said, even assuming that the power seems to be broad, seems to be a blanket authority to almost do anything, in the first place, any decision of a member of the executive or of the Commonwealth executive will always be subject to review by the High Court, because that is based on Section 75 of the Australian Constitution. It will always be subject to review. But even assuming that the power seems to be quite broad and unfettered, there is no such thing as an unfettered or an unlimited power. The Commonwealth Parliament has no power to confer that on any agency of the executive department. Any powers that it confers, in the first place, is always subject to what the Constitution provides, and to whatever other statutes might be in place. But more importantly, even the blanket authority that is given will have to be interpreted in the light of the purpose of the statute, or the aims of the statute, or the subject matter of the legislation. So these still confer a limit on the so-called broad authority. So for as long as a decision maker makes a decision within the boundaries of the purpose of the statute or the subject matter of the statute, then there can be no basis to question the validity of that decision. But if the decision goes beyond the purpose of the statute, or beyond the power given by the statute, or goes beyond the subject matter of the legislation itself, then the decision can be invalidated. Okay? So that's it for us. Do you happen to have any questions before we call it a night? So the one concern, the concern I just have is that more of a reminder is that I'm very concerned, looking at the chat box here, that even if the question that I pose seems to be quite clear, like say I ask, is there a legal ground? In some instances, when I look at the chat box, the answer seems to be extraneous, meaning irrelevant. You have to make sure that your answer addresses the question that I have postulated, or that I have posited. Okay? So which means, therefore, that you must be in a position to clearly identify or recognize what the legal issue is. Don't go beyond that. Because otherwise, if you end up, let's say, the question was a legal ground to challenge, and then you start talking about, is it appropriate for there to be judicial review or a merits review? That is not what the question is asking. Okay, so in that case, you would have failed to correctly identify the legal issue. And so in that case, the answer would be wrong, because you came up with probably the correct answer, but to a wrong question. So that you have to make sure that you address the question that is being raised. Okay, so which means you need to be able to clearly identify what the legal issue is, just as a reminder. So don't go beyond that. Okay? So anything else before we end tonight's session? None? Okay, so thank you again, everyone. Thank you, Matt. Thank you, Andrew, Patrick, Jacqueline, and Paul for joining us tonight. And I'll see you again in about 2 weeks' time because we won't have a tutorial next week. Okay, that's not a problem, Paul. Okay, thanks for coming. See you. Bye.